Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather not have. Today we're going to be providing another installation into our The Federalist Papers series going on number 21. So if you haven't gone back and watched 1 through 20, I would encourage you to do so because as late and great Justice Antonin Scalia had detailed, he said one of the deficiencies the modern legal education system is that they don't teach the Federalist Papers. So if you want a very well-rounded and comprehensive understanding of what the founders understood the Constitution to be, as well as how it actually is, I would encourage you to read through the Federalist Papers. They're a great supplementary base of information, but not necessary when understanding the U.S. Constitution. Now, understanding the U.S. Constitution is, of course, absolutely tantamount when defending against or combating the ever-growing hostile lawfare state. Now, before we get into number 21, I'm excited to announce that I've published my first novel titled Lawfare, Abolish the American Bar Association. If you're curious about the foundational reasons for the Calhoun School of Law, as well as who the deep state actually is, go ahead and pick up a copy of the novel as it explains in great detail how the titular organization, the American Bar Association, best fits the title of deep state rather than these other agencies or entities that we tend to give that title to. So if you're interested in having either of those questions answered, go ahead and pick up a copy of the novel off of Amazon. It's available in digital, paperback, and hardcover. Excellent. So now let's go ahead and jump over to the Federalist Papers. Like I said, we're going on number 21. Now, there are multiple institutions from which you can get both a paper and digital copy of the Federalist Papers from. I would encourage you to do so. While you're out there searching for the Federalist Papers, go ahead and get a copy of the Anti-Federalist Papers as well, because once we wrap it up with the Federalist Papers, we're going to see what the counter-arguments were posed by individuals like Patrick Henry, Thomas Jefferson, George Mason, all of these other equally important founders to individuals like James Madison, Alexander Hamilton, and John Jay. Okay, so this copy I'm using is from the federalistpapersproject.org, but like I said, multiple institutions provide both paper and digital copies, which I would encourage you to do right now, just in case you can't access one or the other if you need a quick reference. Okay, without further ado, let's get on to Federalist Paper number 21, titled Other Defects of the Present Confederation. So if you watch the previous episodes, the past 4 or 5 letters or papers that they published, we're all talking about the same topic, and they gave a whole bunch of historical examples of how separating or dividing into 2 or 3 confederacies is supposedly more detrimental and less organized, less beneficial, we'll say it that way, than if they were to conglomerate under one singular union. So now they're finally getting off of that topic and going to point out other defects that they perceive to be happening with the current confederation. What was that? It was the union. It was the, quote, League of Friendship, as Benjamin Franklin put it, in the Articles of the Confederation, which was formed by the Articles of the Confederation. And of course, the Articles of the Confederation were formally recognized as the governing document from 1777, 78-ish, all the way up until 1785, 1786, which is when the U.S. Constitution started being debated, started being not 1785, 1787, which is when you notice the dates of these papers are mainly in 1787, is when the U.S. Constitution was debated and when it was considered to be installed. Okay. So Federalist number 21, Other Defects of the Present Confederation, written by Mr. Alexander Hamilton, published in the Independent Journal, Wednesday, December 12, 1787. To the people of the state of New York, they were addressed to the people of the state of New York, but because they were discussing ratifying the U.S. Constitution, the terms of the U.S. Constitution, these papers were divvied out to the people of the other 12 states as well for their consideration of the U.S. Constitution. So realistically, these saw quite a few more eyes than just the eyes in New York. Having in the 3 last numbers taken a summary review of the principal circumstances and events which have depicted the genius and fate of other Confederate governments, I shall now proceed in the enumeration of the most important of those defects which have hitherto disappointed our hopes from the system established among ourselves. To form a safe and satisfactory judgment of the proper remedy, it is absolutely necessary that we should be well acquainted with the extent and malignity of the disease. Very similar syntax, very similar phrasing to what's put in the U.S. Declaration of Independence. In the course of human events, something similar to that. The next most palpable defect of the subsisting Confederation is the total want of a sanction to its laws. The United States, as now composed, have no powers to exact obedience or punish disobedience to their resolutions, either by pecuniary mulcts, by a suspension or a divestiture of privileges, or by any other constitutional mode. There is no express delegation of authority to them to use force against delinquent members, and if such a right should be ascribed to the federal head as resulting from the nature of the social compact between the states, it must be by inference and construction in the face of that part of the second article by which it is declared that each state shall retain every power, jurisdiction, and right not expressly delegated to the United States in Congress, a symbol. So that's where our key principle comes in. Everything in the U.S. Constitution are the only powers that are exercisable by the federal government. Everything else not listed belongs to the states and then belongs to the people. The people of the states, not the people of the United States. There is doubtless a striking absurdity in supposing that a right of this kind does not exist, but we are reduced to the dilemma either of embracing that supposition, preposterous as it may seem, or of contravening or explaining away a provision which has been of late a repeated theme of the eulogies of those who oppose the new Constitution, and the want of which in that plan has been the subject of much plausible animadversion and severe criticism. If we are unwilling to impair the force of this applauded provision, we shall be obliged to conclude that the United States afford the extraordinary spectacle of a government destitute even of the shadow of constitutional power to enforce the execution of its own laws. It will appear from the specimens which have been cited that the American Confederacy in this particular stands discriminated from every other institution of a similar kind and exhibits a new and unexampled phenomenon in the political world. The want of a mutual guarantee of the state governments is another capital imperfection in the federal plan. There is nothing of this kind declared in the articles that compose it, and to imply a tacit guarantee from considerations of utility would be a still more flagrant departure from the clause which has been mentioned than to imply a tacit power of coercion from the like considerations. The want of a guarantee, though it might in its consequences endanger the Union, does not so immediately attack its existence as the want of a constitutional sanction to its laws. Without a guarantee, the assistance to be derived from the Union in repelling those domestic dangers which may sometimes threaten the existence of the state constitutions must be renounced. Usurpation may rear its crest in each state and trample upon the liberties of the people, while the national government could legally do nothing more than behold its encroachments with indignation and regret. A successful faction may erect a tyranny on the ruins of order and law, while no succor could constitutionally be afforded to the Union to the friends and supporters of the government. The tempestuous situation from which Massachusetts has scarcely emerged evinces that dangers of this kind are not merely speculative. Who can determine what might have been the issue of her late convulsions, if the malcontents had been headed by a Caesar or by a Cromwell? Who can predict what effect a despotism established in Massachusetts would have upon the liberties of New Hampshire or Rhode Island, of Connecticut or New York? The inordinate pride of state importance has suggested to some minds an objection to the principle of a guarantee in the federal government, as involving an officious interference in the domestic concerns of the members. A scruple of this kind would deprive us of one of the principal advantages to be expected from union, and can only flow from a misapprehension of the nature of the provision itself. It could be no impediment to reforms of the state constitution by a majority of the people in a legal and peaceable mode. This right would remain undiminished. The guarantee could only operate against changes to be effected by violence. Towards the preventions of calamities of this kind, too many checks cannot be provided. The peace of society and the stability of government depend absolutely on the efficacy of the precautions adopted on this head. Where the whole power of the government is in the hands of the people, there is the less pretense for the use of violent remedies and partial or occasional distempers of the state. The natural cure for all ill administration in a popular or representative constitution is a change of men. A guarantee by the national authority would be as much leveled against the usurpations of rulers as against the ferments and outrages of faction and sedition in the community. The principle of regulating the contributions of the states to the common treasury by quotas is another fundamental error in the Confederation. Its repugnancy to an adequate supply of the national exigencies has been already pointed out and has sufficiently appeared from the trial which has been made of it. I speak of it now solely with a view to equality among the states. Those who have been accustomed to contemplate with the circumstances which produce and constitute national wealth must be satisfied that there is no common standard or barometer by which the degrees of it can be ascertained. Neither the value of lands, nor the numbers of the people, which have been successively proposed as the rule of estate contributions, has any pretension to being a just representative. If we compare the wealth of the United Netherlands with that of Russia or Germany, or even of France, and if we at the same time compare the total value of the lands and the aggregate population of that contracted district with the total value of the lands and the aggregate population of the immense regions of either of the three last mentioned countries, we shall at once discover that there is no comparison between the proportion of either of these two objects and that of the relative wealth of those nations. If the like parallel were to be run between several of the American states, it would furnish a like result. Let Virginia be contrasted with North Carolina, Pennsylvania with Connecticut, or Maryland with New Jersey, and we shall be convinced that the respective abilities of those states in relation to revenue bear little or no analogy to their comparative stock in lands or to their comparative population. The position may be equally illustrated by a similar process between the counties of the same state. No man who is acquainted with the state of New York will doubt that the active wealth of Kings County bears a much greater proportion to that of Montgomery than it would appear to be if we should take either the total value of the lands or the total number of the people as a criterion. The wealth of nations depends upon an infinite variety of causes: situation, soil, climate, the nature of the productions, the nature of the government, the genius of the citizens, the degree of information they possess, the state of commerce, of arts, of industry. These circumstances and many more, too complex, minute, or adventitious to admit of a particular specification, occasion differences hardly conceivable in the relative opulence and riches of different countries. The consequences clearly is that there can be no common measure of national wealth and, of course, no general or stationary rule by which the ability of a state to pay taxes can be determined. The attempt, therefore, to regulate the contributions of the members of a confederacy by any such rule cannot fail to be productive of glaring inequality and extreme oppression. This inequality would of itself be sufficient in America to work the eventual destruction of the Union, if any mode of enforcing a compliance with its requisitions could be devised. The suffering states would not long consent to remain associated upon a principle which distributes the public burdens with so unequal a hand, and which was calculated to impoverish and oppress the citizens of some states, while those of others would scarcely be conscious of the small proportion of the weight they were required to sustain. This, however, is an evil inseparable from the principle of quotas and requisitions. There is no method of steering clear of this inconvenience but by authorizing the national government to raise its own revenues in its own way. Imposts, excises, and in general all duties upon articles of consumption may be compared to a fluid which will in time find its level with the means of paying them. The amount to be contributed by each citizen will in a degree be at his own option and can be regulated by an attention to his resources. The rich may be extravagant, the poor can be frugal, and private oppression may always be avoided by a judicious selection of objects proper for such impositions. If inequality should arise in some states from duties on particular objects, these will, in all probability, be counterbalanced by proportional inequalities in other states, from the duties on other objects. In the course of time and things, an equilibrium, as far as it is attainable in so complicated a subject, will be established everywhere. Or, if inequalities should still exist, they would neither be so great in their degree, so uniform in their operation, nor so odious in their appearance as those which would necessarily spring from quotas upon any scale that can possibly be devised. It is a signal advantage of taxes on articles of consumption, sales tax, that they can contain in their own nature a security against excess. They prescribe their own limit, which cannot be exceeded without defeating the end proposed, that is, an extension of the revenue. When applied to this object, the saying is as just as it is witty that in political arithmetic 2 and 2 do not always make 4. If duties are too high, they lessen the consumption. The collection is eluded, and the product to the treasury is not so great as when they are confined within proper and moderate bounds. He sounds like Milton Friedman. This forms a complete barrier against any material oppression of the citizens by taxes of this class and is itself a natural limitation of the power of imposing them. Something he and I can actually agree on. Impositions of this kind usually fall under the denomination of indirect taxes and must for a long time constitute the chief part of the revenue raised in this country. Those of the direct kind, which principally relate to land and buildings, may admit of a rule of apportionment. Either the value of land or the number of the people may serve as standard. The state of agriculture and the populousness of a country have been considered as nearly connected with each other. And, as a rule for the purpose intended, numbers, in the view of simplicity and certainty, are entitled to a preference. In every country, it is a Herculean task to obtain a valuation of the land. In a country imperfectly settled and progressive in improvement, the difficulties are increased almost of impracticability. The expense of an accurate valuation is in all situations a formidable objection. Excuse me, I almost reread that line. In a branch of taxation where no limits to the discretion of the government are to be found in the nature of things, the establishment of a fixed rule, not incompatible with the end, may be attended with fewer inconveniences than to leave that discretion altogether at large. So that's the end of number 21. If you have any questions about what Mr. Hamilton said there, and a little bit of that I actually agreed with, surprisingly. Well, not so surprisingly. I've read through these. But point being, Mr. Hamilton, quite the nationalist, quite the centralist. For him to say the only tax that the federal government should be able to impose is one on imports, a sales tax in general, good for him. At least he had some sort of consideration for historical trends. But anyway, I digress. If you have any questions about what Mr. Hamilton was saying in number 21, or any questions about the topics relating to Federalist Papers 1 through 20, post those in the comments. If you have any topics you'd like me to cover in a future lecture, maybe we can divert from the Federalist Papers and the U.S. Constitution amendments temporarily to attack maybe a more contemporary topic or something more pressing. Also post those in the comments because, like I like to say in each of these videos, the entire point of the Calhoun School of Law and these lectures being posted on Rumble is for your benefit, and I would rather serve that purpose exceptionally rather than insufficiently. So if there's any way that I could improve, help you learn better, digest this information quicker, more efficiently, more effectively, also post those in the comments. Why? Because it's not a matter of if, ladies and gentlemen, but when this ever-growing hostile lawfare state comes to harass you, your loved ones, or your property, that I want you to be well-equipped and capable of defending against those barrages for the sake of yourself, for the sake of your loved ones, or your hard-earned property. So please, if you have any questions at all, or any topics you'd like me to cover, post those in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture. Again, if not, let me know how I can do better. I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining, if not more so than this one. Until that next lecture, I hope you all have a wonderful day, and I bid you all farewell.